Hello everyone, welcome to Ray Academy. My name is Shankar Ray. Today we are going to learn some of the very important aspect of answer writing. Okay, great. So what we are going to learn today, the UPSC pattern answer writing. Can you write an answer? Now, all of you know that UPSC pattern of answer writing is completely different than what we generally write in our academic. Okay, if you do not know, then make sure that you know it. Many of you, at any point of your life, you might have attempted to write any answer in your college or university. Okay, so let me give you one example. For example, let's say you are a student of political science, political science, and there is a chapter of fundamental rights. Now, no doubt, the same topic also you are going to learn in the civil services examination. But the difference is the way you learn the analytical part, and the analytical part is completely different than what you are learning in the UPSC. Great. So my motive is very clear to make you aware and train you for the UPSC pattern answer writing. That is my motive, and to do so, to do so, I'm going to give you a live example through which we can learn how to write a good answer. Now, first of all, why the answer writing is important? All of you are aware that the mains examination holds a significant weightage in the civil service exam. Okay. So the prelims is MCQ types, but the mains examination where you have to write answer. And there are different papers, like for example, general studies, optional. Okay, then you have your essay paper, then English paper, and language paper. So this is extremely important for those students who are preparing for civil services examination, be it UPSC or maybe state civil service. So the objective of today's live discussion is to enrich your answer writing skills, is to develop the answer writing skills. As I have already told you that the UPSC pattern of answer writing requires certain skill set, and you have to develop the skill set. Do not be in a misunderstanding that the skill set can be developed overnight. No, you have to really focus on developing the skill set step by step, gradually, incrementally, and that you can do it only by practice. Okay, so let us practice then. Okay, I'm very excited. Now, this is the question. Do you think the Constitution of India does not accept principle of strict separation of powers rather than it is based on principle of checks and balance? This question was asked in UPSC Civil Services Examination 2019, General Studies 2 paper. Okay. So this is a actual live question which was asked in the examination, and I'm going to teach you how to write a good answer by giving an example. Excited? I'm also equally excited to interact with you people, and let us learn the answer writing skill. Great. Let us start. So the question is, do you think the Constitution of India does not accept the principle of strict separation of powers, rather it is based on principle of checks and balance? Okay. Now we try to answer this question. We try to answer this question. Now, how do we answer? Remember, the civil services examination, they never ask a question where the answer is yes or no. You will never get a question in that. Always the questions are much more analytical or and linked to contemporary events. Okay, so you must prepare yourself accordingly. Okay, you have to prepare accordingly. Now, to do so, what we are going to do? We take off this question as an example. We try to answer this. Then we will understand how to write an effective and good answer which can fetch you maximum mark. Because the objective is, the more mark you get, the more mark you get in the civil service mains examination, higher is the chance to secure a good rank. Okay, so our objective is to face maximum marks in these particular questions. Now let us start. Now in order to answer this particular question, do you think the Constitution of India? Okay, remember aspirants. One thing I must tell you, that whenever you jump to a right answer, which I mean, before you write down an answer, always read the question at least minimum 2 times. I have seen this mistake is done by majority of the aspirants where they jump to the answer without understanding what is the demand of the question. Unless and until you understand the demand of the question, how can you answer? Okay, and it is not just they read couple of few words and sentences, they think that the question is all about that. No, it is not. You have to understand the demand of the question by reading between the lines and words, then only you can understand. Okay, great, good to go, fantastic. Now let us then as we have understood what is the requirement, and what is the requirement, the requirement is to tell or answer whether our constitution, whether the Constitution of India, uh, it is not having a strict separation of power, but it is based on the principle of checks and balance. Okay, now to answer this particular question, I must tell you that you need to understand two concepts. One is strict separation of power, and the one is principle of checks and balance. Okay, This is number one. You have to understand strict separation of power. What is strict separation of power? What is the separation of power? And what is the principle of checks and balance? Great. So these are the two important topics which you need to understand. Unless and until you understand these two topics, you will not be able to answer this question. So what is our objective? What we are going to do? First, we understand these two topics. Okay. Second, we try to write answer. Okay. Great. Good to go. Now let us first focus on one. That is, I must say, separation of power. Now the separation of power. This separation of power is also known as theory of separation of power. The concept comes from the theory of separation of power. Now, what is the concept of theory of separation of power? Talks about. First of all, we have to understand where does this concept come from? This concept of theory of separation of power comes from Montesquieu. And who is Montesquieu? He is a French political philosopher. Okay. So the theory of separation of power is given by Montesquieu, who is a French political and philosopher. Now, what exactly he gave in the theory? Now, he told that the three wings of government, I'll make sure that you understand each and every bit. And generally, my style of teaching is to engage and, the nutshell storytelling way. So you are going to enjoy. Three wings of the government or three organs of the government. What is the theory? The theory says Montesquieu proposed that the three wings of the government, which is legislature, executive, and judiciary, shall be complete separate from each other. Okay, they shall be complete separate from each other. So that is the theory given by Montesquieu, which means watertight arrangement. I do not go by the literal meaning of watertight. Watertight means water cannot pass from one compartment to another compartment. So that is the only meaning to understand that legislature cannot interact with the executive. So is the case for judiciary. Judiciary cannot interact with the executive. So is the case for legislature, which means legislature, executive, and judiciary, they have to work independently. Remember, these all are power. So they will exercise their power independently, completely. Okay. And there cannot be any interference, no interference among each other. Okay, which in a very simplistic way, legislature cannot intervene into the work of executive, and executive cannot intervene into the work of judiciary. Okay, I hope I am extremely clear on the points. that Montesquieu gave the theory of separation of power, and he proposed the three wings of the government, or the three organs of the government. Number one, legislature; two, executive; and three, judiciary, shall be completely separate from each other. Okay, but why he gave the theory? Why he gave the theory? What was the objective behind giving the theory? What is the objective behind giving the theory? Number one, to prevent concentration of power. To prevent concentration of power. There is a famous saying that power corrupts. Absolute power corrupts absolutely. I repeat, there is a famous saying, power corrupts, absolute power corrupts absolutely. Which means, if you want to know somebody, be it a person, give him or her power. A power can be in terms of, let's say, position, or maybe money. There are different meaning of power. That is a concept of political science optional, which I am not going to discuss here. So the power concentration of power, to prevent the concentration of power, this is one of the objective. And what will happen if the power is concentrated? This is primarily, all of you know that you are also aware, the history is witness to have many person, or maybe kings, who have accumulated power and became dictatorship or authoritarian. Okay, so when the power is concentrated in one hand, or hands of few, it is expected that it will be abused. It will be abused and it will be exploited. Did you get what is the first objective? To prevent concentration of power. And not only that, I also explained you what will happen if the power is concentrated. So that brings to me the second aspect, or second objective, is to protect personal or individual liberty. Am I clear? So, liberty has a many meanings. Like, for couple of example, liberty is a vast concept, which is also comes under the political science optional. So, in a nutshell, liberty, one of the type of liberty, you can say freedom. Freedom of expression, freedom of speech is one of the liberty. Another way of liberty by saying privacy. Okay, another way, way of living. You can live the way you want, so that is the individual liberty. So if the power is concentrated, it is expected that the people, or the person who is going to hold the power, or the institution who is going to hold the power, will abuse or exploit. And by turn, what will happen? It will impact the individual liberty. So those are the two objective on which Montesquieu proposed that theory of separation of power, the three wings of the government, legislature, executive, and the judiciary, shall be completely separate from each other, to prevent concentration of power and to protect individual liberty. Okay, great. So now, as we have understood that theory of separation of power, the theory is always a theory. Many people, they have given a theory, but unless and until it has some legal basis, it doesn't matter at all. Okay. Now, interestingly, what happened? US is the first country to give legal basis to theory of separation of power. and hence became doctrine doctrine of separation of power. Am I clear? So US is the first country that gave legal basis to theory of separation of power and hence became doctrine of separation of power. Doctrine is, it's a legal language that when your theory has legal basis, then you have certain doctrine, certain principles based on which your legal values will function. But interestingly, what happened? USA, while incorporating into their constitution, that means US constitution, it did not accept as it is. No, it made few changes. Okay, so let us try to understand what are the few changes, what are the changes, and why. So why US made few changes and why it did, and what are those changes to the doctrine of separation of power. Number one change, it rejected complete separation. Am I clear? So it rejected the complete separation. What do you mean by complete separation? It USA, while incorporating to its constitution, it held that the three wings of the government, legislature, executive, and the judiciary. Do you remember the Montesquieu proposed that these three wings of the government shall be complete separate? But while US incorporating to their constitution, what they did, they rejected this particular watertight arrangements and they held that they allowed a little bit of interaction among three wings of the government. And what was the reason behind it? Okay, let us understand what is the reason behind it. The reason is, let's say, because of some reason, one wing of the government, let's say the legislature, is not functioning well. Then what will happen? This legislature, executive, and judiciary, they are like pillar on which the entire country is standing. So what will happen if one pillar is breakdown? Then definitely it is expected to fall or imbalance. Then there is no other way because if there is a complete separation between three wings of the government, then there is no other way to help each other. So what they did, they allowed a little bit of interaction among each other so that in case of certain situations they can support each other. Okay, and they can also seek necessary advice from each other. So that is like a helping hand to, when one wing is not functioning well, so that the other wings will be able to extend help. So that is one of the reason why it completely rejected the complete separation. Otherwise it would have been a disaster. Now the second change, what it made, the second change, what it made, that it introduced the doctrine of checks and balance. Okay. Now, number one change, as I told, that it rejected watertight complete separation. And number two change it made, that it introduced doctrine of checks and balance. Now, do you remember the legislature, executive, and judiciary? Now, with change number one, it allowed little bit of interaction among the three wings. Now, when there is a way, it is also expected that the the relation can be abused. or some may misuse. Now, what if one of the wing legislature, let's say, overexercises its power? Overexercises means, let's say, legislature. What is the work of the legislature? Is to create or make laws. What is the work of the executive? Is to implement the laws framed by the legislature. And what is the work of judiciary? Is to check it whether the law is in accordance to the principle that is laid down or the constitution. I hope I am clear. So now what happens? What do I mean by over exercising? Which means if legislature will over exercises its power and will enter into the domain of, let's say, exercise, domain of executive, which means, there are certain boundaries that yes, these are the one, two, three, work that is done by legislature. For executive, these are the role by the executive. For judiciary, these are the areas where the judiciary can function. If one will over exercise its own power and will enter into the domain of other, then what will happen? Then it is a problematic, it will be a chaotic. So there must be some mechanism to check it. Check means stop to stop it and restore the balance. What is the balance? This is the balance. Legislature, executive, and judiciary. This is equilibrium. Oh, okay, so they must work in sync. So that is the concept of doctrine of checks and balance. I'm going to explain you the doctrine of checks and balance in a much more elaborate way, little bit minutes after. Great. Now, what we have understood? We have understood that number one, what is the theory of separation of power? Who proposed? Why he proposed? And who adopted? It is the US adopted. But while adopting, US made two changes. Number one, it rejected the complete separation of power and it introduced doctrine of checks and balance. Interestingly, why we are learning today? Of course, if the question is being asked in UPSC, then it is of immense importance. Now, why learning? Unless and until it is relevant to India, it is of no use. Now, let us try to understand how it is important to India. Okay, what do I mean by that? Does India also incorporates the, let's say, doctrine of SOP, theory of separation of power? So that is what we are talking about. So does India incorporates the doctrine of separation of power? In other way, as our constitution also includes this theory of SOP. Okay, so let us try to understand. Interestingly, there is a very famous case, and if you are a student of UPSC then or civil services examination, then you must know it is Keshavananda Bharati versus state of Kerala, 1973. If you want me to be precise, then it is 24th April, 1970. It's okay if you do not remember the date exactly. Just remember the case. Keshavananda Bharati versus State of Kerala. Now, why it is important? Now, of course, we are not going to discuss about the case, rather how the case is linked to the topic which we are discussing. Now, this Keshavananda Bharati case, now where the Supreme Court of India held that the theory of or the doctrine of separation of power is incorporated into also the Indian Constitution. Okay, which means India has doctrine of separation of power. Also, it held that the Supreme Court of India, while making this particular judgment, also told that it also comes under the basic structure. Okay, I will explain this basic structure a little bit later on, not now. Great. Now, in this very famous case, Keswananda Bharati versus State of Kerala, the Supreme Court held that yes, we have the doctrine of separation of power. Great. Then let us understand more of this particular separation of power from the India's context. Now, what India did while incorporating into our own constitution, we also made two changes, like USA, as I told earlier. Number one, we also rejected we also rejected complete separation. Okay, so what is the meaning of we also rejected the complete separation? Now, when we talk about the rejecting the complete separation, it means already I have explained that how can the three wings of the government, legislature, executive, and the judiciary, can help each other. Okay, that is the reason if it will be completely separated, then it is going to create some problem. And India has realized, and India rejected the complete separation and allowed little bit of interaction among these three wings of the government. Clear? Already I have explained the reason for that. Now, second, it also incorporated doctrine of checks and balances. Okay. Now, with the continuation of the theory of the separation of power context, the number one change. So, do you know that in our constitution, Article 50, it explicitly says that judiciary is separate from executive. Okay, so judiciary is separate from executive. That is Article 50 of our constitution. So in order to implement this Article 50, now what we did, we made some changes to our criminal procedure code, simply CRPC 1973. So what change we made? The power exercised earlier, what used to happen, the power exercised by the judiciary magistrate and executive magistrate. Executive magistrate, they were the same person. Okay, earlier that used to happen. But in order to implement this Article 50, what we did, no, it cannot be possible that the judiciary executive will exercise judicial power. That means that the judicial magistrate will exercise the judicial power, and the executive magistrate will exercise the executive power. Clear? Because judiciary is a different wing and the executive is a different wing. So for that, judiciary magistrate will exercise the judiciary power and the executive magistrate will exercise executive power. Now that is the change which we have made to our own procedure of the criminal conduct. Now in a continuation, what we did further, the change of doctrine of checks and balance. Now, when we say about doctrine of checks and balance, of course, if I am going to say nobody is going to believe, neither it is acceptable. There has to be some legal basis. Now, what happened? The Supreme Court further held in a very famous case of Converson versus State of Tamil Nadu, 1996 case. It held that yes, Indian Constitution also has the doctrine of checks and balance. Now let us try to understand the doctrine of checks and balance in a much more elaborate way. Now, for example, legislature, executive, and judiciary. Now, as I have told, what is the work of legislature is to create law. Executive is to implement it. Judiciary is to check it, whether the law is in accordance to the principle of the constitution or not. Now, what if, let me give you one example. For example, legislature, our union legislature, parliament. Let's say parliament has framed a law, or let's say passed a law, which infringes or conflicts with our fundamental right. Okay, that means normally what happens, the parliament is not supposed to make any law which will violate the constitution, as the fundamental rights are explicitly written in the constitution, that is part 3 of our Indian constitution. Suppose the parliament has made some law that violates the fundamental rights, then what will happen? The judiciary has the power to struck down the complete law. It is possible. Okay. Now, at the same time, let me give you one real example. Let's say NJSC, National Judicial Appointment Commission. The NJSC Act, it was indeed a constitutional amendment act. Now, the judiciary, and the judiciary means the Supreme Court of India, found that Article 124, this is having a chilling effect to independency of judiciary. So what it did, it completely struck down the entire act. Okay, so that is the power of judiciary it is having. So on the contrary, there are several acts which does not, in accordance to the, let's say, the law or the constitution, then the judiciary has the power. Okay, let's say executive has made some decision or passed any order. If the judiciary or the parliament thinks, or the legislature wing thinks, that it is not according to what it's supposed to have, then the judiciary can struck down, or the parliament can pass a law to also even struck down the order of the executive. And when we talk about executive union, it is primarily the prime minister plus council of minister. Okay. So similarly, let's say judiciary has passed a judgment. Judiciary has passed a judgment, or let's say passed a decree, not degree, yeah, DECREE, decree, which is supposed not to pass it. Then what will happen? Parliament or the executive, they can create a law and they can turn down the particular judgment. Now the objective is very clear. Why they have the power to check it? So that they can prevent the over exercising of power. so that they can prevent the over exercising of power. Great. Am I clear? Now, generally what happens, though we have a checks and balance, but it is not expected that the three wings of the government, legislature, executive, and judiciary, will fight with each other. Now, it is well understood, no doubt, in the constitution is not 100% clear that what is the role of legislature and executive and judiciary, and it has not explicitly and 100%, it has not laid down each and every role. Why? Because role are always subject to evolution according to time and situation. Okay, so it is expected that they will sense that particular change and they will not enter into the domain of other. That is called as checks and balance. I hope I am extremely clear on that point, to make you understand what is the checks and balance. Did you realize that it is not about how much power you have, but it is, primarily based on the checks and balance? Isn't it that clear? That is the reason why do you think the Constitution of India does not accept the principle of strict separation of power? Of course, we do not have a strict separation of power. Rather, our separation of power is partial. Partial. Already, I have explained the reason. The Article 50. Then also, I have explained helping each other. That is the doctrine of separation of power. Rejecting the complete separation. Rather, it is based on the checks and balance. And it is great to know that we have really understood the concept of the separation of power as well as checks and balance. Great. We are then ready to answer this particular question. Do you think the Constitution of India does not accept principle of strict separation of power? Now, never start with yes or no, which means do not just write down the answer that yes, I think Constitution of India has, or I do not think. Do not write down in that way. What is the format? First introduce, then write some summary or the body part, then conclude your answer. Now, to introduce, you must understand, as I told that repeatedly, I have been telling you the same thing, that you have to first read the question multiple times to understand the demand. Here, the question is not asking about the theory of separation of power. It is not asking you to explain what is the theory of separation of power. Neither it is asking about to explain the checks and balance. Rather, it is asking the demand of the question is related to India's context, whether it is having a principle of strict separation of power or not, and how it is more inclined to the checks and balance. So that is the demand of the question, the crux of the question. So first introduce it in a one line or two line related to the the strict separation of power SOP structure. As I have already given you the explanation, what is SOP? Just one or two lines, write it down. Then in the body part, try to write down how this SOP is linked with India's context. And what do I mean by India's context? Already I have told there are provisions of Article 50, the CRPC, the Keshwananda Bharati case, I have already explained you, 1973. So try to put those information. Remember, when you write down the information in UPSC, it is not just about write in a general way. What do I mean by general way? For example, suppose this question is being asked and you write that yes, I think theory of separation power is good. It is very important and we should have it. So this is a more of a way of answering, a kind of in a very generalistic way where it signifies that you do not have much of information, you do not have much of depth of knowledge to answer this question. Rather, you must make some references. And what are those references? You can make references of article of the Constitution, or maybe judgments of the judiciary, Supreme Court or High Court, or even you can also quote certain, let's say, committee report. Okay, these are the some validation to your answer. This shows that yes, you have prepared well, you know the answer, and it is not only that you are telling from the general point of view, but also you have certain references to make your answer more solid. I hope I'm extremely clear on that. Now, in the body part, as I told, that please write down how this separation of power is linked to India. Then you write down about the checks and balance. I have already explained you that like Karnataka versus state of Tamil Nadu 1996 case, and moreover, based on the checks and balance, there are a couple of more points which I want to cover. All of you know that a minister is a part of executive. A minister is also a member of parliament, which is a part of legislature. Okay. Yes, there are certain provisions that without being a member of parliament, you can become a minister up to 6 months. So I'm not talking about that exceptional point of view. I'm talking about the general concepts. So that means a same person is also part of executive, same person is also part of legislature, isn't it? So this is also another part of, you know, partial separation of power. Here it is saying does not accept the principle of strict separation. This is one of the examples where we do not have a strict separation. The same person has exercising different positions at different situations. Now, there are also many examples where you can highlight that the parliament selects the leader, and the leader is appointed as prime minister by the president. Okay, it is a parliament who does that. Parliament is exercising its power and appointing the to the executive head. That is the real head of the executive, Prime Minister of India. Then further, Prime Minister further the President of India appoints the individual minister uh, with at the advice from the Prime Minister of India. Okay. Now, the ministers are accountable to the president, but the member of parliaments are accountable to the Lok Sabha. Okay, can you get it? Now, these are the some certain overlapping areas. These are certain overlapping areas where we do not have a strict separation of power. Rather, it is a partial separation. I have written somewhere. Anyways, it is a partial separation. Great. Now, we are very much clear. First, introduce, then write in the body part according to the demand of the question, then conclude your answer. In conclusion, you can always say that our Indian constitution is incorporating not strict separation, which is extremely important from the point of view to give benefit and to help to support the wings and their correlations among each other. Right? And there cannot be a standard answer, so the answer will vary from person to person. Great. So I think we have covered a lot of things today, and can you really realize that in order to answer this one question, we had to go through the different concepts, two concepts, I must say, and not only the concepts. It is not only the one of the definition of one concept, but also different aspect, like from theoretical aspect, from USA point of view, from India point of view, from judiciary point of view, from legislature point of view. Okay, it's all about correlating the entire topics from different picking up different points and culminating into one thread that makes your answer much more solid, that can fetch you a maximum marks in your examination. Now, if you want that you want to evaluate an answer, I will request and encourage each of you to kindly write down this answer. Do not think about um, no, it cannot be a great answer. It's absolutely okay. I have seen many aspirants, um, they think that yes, I know the topic or I have read the topic, but I do not want to write down now. I will write directly in the examination. That do not do that mistake, please, because it is going to harm you and you will not be able to answer. The problem, because why I'm highlighting, uh, you know, you are going to face the problem only when you write. So first, write. Step number 01. Remember, there is a quote: journey of 1,000 miles starts with one step. Okay, journey of 1,000 miles starts with one step only. And I hope that you take the first step. Just write down. You do not expect that you on the first day itself you will be able to write down an exceptional well answer. Forget about it. Write it down the way you want. I have already given you the content, what to write. Just summarize it, organize it and write it down. And if you want certain feedback after understanding or writing that, of course you need some evaluation. Okay, if you want me to give you some feedback that how is your answer or what improvements you require, then I will encourage you to write down the answer and send me in my email, which is help@ray.academy. Okay, this is my email ID, and do not forget to mention your name so that I'll be able to understand you better. So please write down this answer and send it to me to this email, help@ray.academy. It's okay. I will be happy to help you, to support you, to guide you, and to enrich your answer so that you can score well and you can get a good rank in your civil services examination. Great. And do not forget and never ever hesitate to shoot your answers to me. If you are not clear about, if you do not have any questions now, and while revising the topics, if you find some questions, then feel free to answer me, feel free to question me in the email as well as the mobile number which you have, which is mentioned, so that I'll be happy to help you. I'll be giving you the necessary guidance within my limited capacity and within my limited knowledge which I have. Thank you so much for joining me live, and it was a pleasure talking to you. It was a pleasure interacting.